So today we're going to talk about urgency clauses. Basically, bills signed into law by the governor that contain an urgency clause become urgency statutes. And the California Constitution, Article 4, Section 8 discusses urgency statutes. In Section 8C3, it says that urgency clause bills go into effect immediately upon their enactment. This is obviously a major distinction between a regular bill and an urgency bill. A regular bill takes effect on the following January 1 after enactment. So a bill enacted in the 2022 legislative session generally takes effect on January 1, 2023. However, an urgency statute takes effect immediately. So what determines an urgency? Section 8D of Article 4 speaks to it, and it says that urgency statutes are those necessary for immediate preservation of the public peace, health, or safety. Because of this definition, an urgency measure must contain an urgency clause that specifies why the bill qualifies for this special status based upon this language contained in Section 8D. Section 8D of Article 4 also requires a statement of facts that constitute the necessity of the urgency, and that statement of facts has to be set forth in one section of the bill. We do this in a plus section at the end. And an urgency statute has to be passed separately by roll call vote, 2/3 of the membership concurring. So not only is the urgency clause required with the relevant explanation, but also the legislature must vote on the urgency clause itself. So what you will hear is after an urgency statute has been taken up, debated, and voted upon, the same vote is utilized twice. So the presiding officer will say, AB 123 with an urgency passed 77-0 and 77-0 on the measure, or they'll say 77-0 on the urgency. And that is because that is a constitutional requirement that there be those two separate votes. The other thing to note in Section 8D is there are certain types of bills that cannot be an urgency statute. So an urgency statute cannot create or abolish any office. It can't change the salary, term, or duties of any office. It can't grant any franchise or special privilege. And an urgency statute cannot create any vested right or interest. So these types of bills are simply not allowed to contain an urgency clause and cannot be enacted as an urgency statute. So due to these constitutional provisions, the two major distinctions with an urgency statute as opposed to a regular statute is the vote threshold and the effective date. Again, the vote threshold is 2/3 rather than majority vote, and it takes effect immediately upon enactment, which includes signature by the governor and the ministerial role of assigning a chapter number by the Secretary of State. So those are urgency clauses in the California legislature in a nutshell.